All right, let's jump right in. We all kind of walk around with this idea of our basic rights, right? Things we just assume are, baked into the very fabric of our laws. But what if a lot of that is just plain wrong?
Seriously, think about this for a sample. The ability to bathe, to wash your clothes, it feels about as basic as it gets, doesn't it? You'd think, for sure, the law has our back on that one.
Well, the short, sharp answer is no, not even close. If you look at the common law, and that's the ancient bedrock of our legal system, the stuff built up over hundreds of years of court cases, there's just no inherent right to be clean. It's a pretty wild answer, I know.
But hang on, stick with me here. Because when we start digging into why that is, it reveals something totally surprising and honestly really important about where our rights actually come from. And trust me, it's probably not what you're thinking.
So, let's really get into this. Why on earth didn't the common law, this grand old system of justice, ever get around to recognizing a right to, basic hygiene?
Well, it turns out the law just looked at it completely differently. To the old common law, bathing wasn't some big deal about human dignity or public health. Nah, it was just a private chore, something you did at home. It was considered an incidental use of water, something handled by local customs, not a legal right you could actually enforce against other people.
And right there, that's a huge blind spot in how the common law saw the world. To really get it, we need to look at what the law actually cared about protecting.
So check this out. This really lays it all out, doesn't it? On one side of the scale, you've got everything the common law was obsessed with. Property, your status in society, keeping public order. And on the other side, well, you've got things like your personal well-being, hygiene, sanitation, even housing. All the stuff we think is crucial today, it was just completely off the radar for the common law. Now you might be thinking, hold on, what about water rights? Surely that covers it. And we do have something close, it's called riparian rights. Basically, if you own land next to a river, you get to make reasonable use of the water. But that phrase, reasonable use, that's where the devil is in the details. Because look at what that actually meant. Even with those rights, bathing was never a primary right. It wasn't on the same level as, say, fishing or using the river for a boat. No, it was just a permissible use. That means you could do it as long as you didn't bother anyone else. It was conditional. It could be taken away. It was absolutely not a fundamental right. And here's another nail in the coffin for this idea, the public trust doctrine. This is about what the public as a whole could use big waterways for. And what was on the list? Navigation, commerce, fishing. This serious stuff. And what was not on the list? You guessed it. Bathing, laundry, even just having fun. Nope, not important enough. So if you imagine our legal system as this big old map, a right to be clean isn't just in some tiny forgotten town. It's not on the map at all. It's completely outside the territory of what the common law was ever designed to do. All right, to really hammer this logic home, let's pivot to a different, maybe a more provocative case study. Let's talk about public nudity. So, does the same logic hold up here? If there's no right to be clean, is there a common law right to be, naked? Like on a public beach? Is that some kind of fundamental freedom? And the answer, maybe unsurprisingly at this point, is a big, fat no. This quote says it all, really. The law doesn't see public nudity as a protected liberty. It sees it as a regulatable act. In other words, it's not a freedom to protect, it's an action to control. And man, the law had a whole bunch of nasty labels ready to go for it. We're talking indecent exposure, breaching the peace, a public nuisance. It was always framed as a potential problem that the local government had to manage, never as an individual right to be defended. You could almost see the law's default setting, can't you? Whenever this stuff came up, its instinct was never to protect it as a right. The instinct was always to regulate it. The only tools in the toolbox were to ban it, license it, or stick it in a segregated area. Protection just wasn't an option. Okay, and this all boils down to a core piece of legal thinking that is so important to get. And it's this. In the eyes of the common law, just because something isn't banned doesn't mean you have a right to do it. Silence does not equal a right. It's basically a three-step logic. 1. For something to be a right, the law has to explicitly say it's a right. 2. Pretty much anything you do in public can be regulated by the government. So 3, the absence of a ban doesn't magically create a right, it just means nobody's gotten around to regulating it yet. And that's the whole reason modern nude beaches exist. They're not there because of some ancient hidden right we all have. They're there because someone passed a specific law that grants permission in that specific place. They're a legal carve-out. They're the exception that proves the rule.
All right, so we've talked about baths, we've talked about beaches. Kind of a weird journey, I know, but why does any of this old legal history matter today? What's the real takeaway here?
It matters because that same blind spot we've been talking about, the common law's obsession with property over people's well-being, has huge, huge consequences for so many rights we now think of as non-negotiable.
Just look at this. The right to housing, the right to an education, healthcare, even the clean water we started this whole thing with. Where did those rights come from? The answer is staring us in the face. It wasn't the common law. They all come from modern statutes and constitutions, laws that people had to fight for and write down pretty recently in the grand scheme of things.
And that right there is the big idea. So many of the rights we assume are ancient and fundamental. They're not. They're actually recent, hard-won creations. We didn't just inherit them. They had to be built, piece by piece, often through long, hard fights. They aren't the default setting. They're an achievement.
So that leaves us with a pretty heavy question to chew on, doesn't it? If the rights to things as basic as housing, health, and hygiene weren't part of our legal DNA from the start, what other rights are we taking for granted right now that might be standing on shakier ground than we think?